Welcome once again to Lehto's Law. Here's Steve Lehto.
I've done videos recently about class action lawsuits, and I also have done videos in the past about people who sue over food labeling. Food labeling. So if you buy something that says vanilla such and such, does it contain actual vanilla? Or does a strawberry Pop-Tart contain any actual strawberries? And I did a whole bunch of videos a while back on those. And recently I've had people asking me, do all those lawsuits win? Do attorneys make money on all those lawsuits? And Michael sent me a note and said, Steve, check this out. The answer, of course, is no. Not all attorneys make tons of money off these lawsuits. And in fact, here's one that kind of backfired. Steve Corus wrote this from MadisonRecord.com. Arizona Beverages awarded $154,000 as a judge finds the attorney pursued a fraud claim for a plaintiff who loved the product. Wait, you might go, Steve, how do you determine someone likes a product? Oh, you take their deposition, put them under oath, and ask them questions. And that's what happened here. U.S. District Judge awarded $154,000 to lawyers for Arizona Beverages for work that another lawyer put them through on a claim that had no chance of surviving. At least that's how it's being phrased here. The court found the attorney acted in bad faith as attorney for the named plaintiff. And the judge wrote, whatever reasonable belief the plaintiff might have had that he was a defrauded customer or suffered actual damage disappeared with his own testimony. Arizona Beverages sought only the fees it charged after the named plaintiff's deposition. And so the attorney had filed the complaint back in 2022, claiming that Arizona Beverages put deceptive labels on 20-ounce cans of its Arnold Palmer Light mixture of tea and lemonade. Light, L-I-T-E. Question always is, does that mean anything? What does light mean? What does light mean? The attorney wrote, far from being light and low in sugar, sugar is the second most predominant ingredient in the product by weight. The product's representation as light is misleading because it is not low in calories. He alleged consumer fraud, unjust enrichment, breaches of contract and warranty, negligent misrepresentation, common law fraud, and consumer injunctive relief. So Arizona Beverages had to hire attorneys, going into court. They moved to dismiss, and a couple years ago, the judge dismissed all claims except for the consumer fraud and unjust enrichment. At that point, an attorney for Arizona deposed the named plaintiff and then moved for summary judgment, which is where you ask the court to dismiss the claim because there's no reason to go forward. And they argued that the named plaintiff couldn't prove causation, deception, or damage because, number one, he couldn't swear that he purchased the product with the label identified in the complaint. And apparently there's a 20-ounce can and a 23-ounce can, and they are slightly different in how they're labeled. And so the attorney said that the plaintiff continued buying the product after claiming he formed a belief that he'd been deceived. He said that the named plaintiff preferred 23-ounce cans and only bought the 20-ounce cans when the 23 wasn't available. When asked about it under sworn deposition testimony, the plaintiff said it was the best product and value, and the price was fair. And remember, these are things that are alleged in the complaint, that the product isn't as promoted, it's too expensive, I'm being ripped off. Oh, it's the best product, the value's good, the price is fair, and I like it. I like it. Even though I thought I was being ripped off, I kept buying it and drinking it. The judge granted summary judgment, finding that the named plaintiff based his claim on a single label, and there's no real indication that he ever saw it. So he's going to be asked these things under oath, and apparently said, I don't know, not sure. So the judge wrote, without at least some evidence of actual damage, plaintiff's action cannot proceed. Arizona Beverages moved for an award of fees, and the judge heard those not so long ago. The attorney stuck to his position that he thought the case was still worthy of pursuing. He said that the Arizona Beverages attorney's actions were in some way intended to chill and punish. He said he believed that the motion was made in bad faith, But the judge granted it, so it wasn't made in bad faith, presumably. So the judge told the attorney that he had practiced almost exclusively on the plaintiff's side and that he had cases that looked good for a little while. He says, you take the deposition, you find out some things through the assistance of a defense attorney that I didn't discover, and I have to reassess at that point whether it's a viable claim, whether I have a different theory, he said. My concern is a decision just to press on. And so the judge is saying, look, once you realized you had no case, it was your job to say, hey, I got no case here. So the attorney says that his client's testimony, that he became aware of the sugar and caloric content, was not dispositive. He also thought it was a better option than other options, and that's because he believed that it was light. So the attorney is arguing and saying that the fact that it said light on it somehow is what's going to get him to win here. He said that his client wasn't in a position at the time to answer the attorney about damages. Whether or not he paid a fair price, I think that's sort of disingenuous. That's for the court to decide. Well, unfortunately for him, the court has decided. So the court granted the fees, finding that the plaintiff didn't argue that he'd suffered any actual damage, nor does he now contend that he's misled by the product's label, except to say that it contained the word light. But again, he kept buying and consuming the product. Here, the judge is saying he's going to make this attorney pay the costs from the moment of the deposition going forward, because he's saying at that moment, that's when the attorney should have realized that his case was done. And so he said to penalize a party or attorney for making adjustments when necessary and timely would be inappropriate. So if the attorney had dropped his case right then and there, would not have gotten hit. But here, plaintiff pressed onward with his claim, despite what should have been seen as an insurmountable obstacle to recovery. So he found that the attorney could have switched out plaintiffs if he found some other plaintiff who'd been harmed here, suffering an actual injury, but he did not do that. So the case gets dismissed, and the judge awards Arizona Beverages $154,000 in costs for having to pursue the case beyond the deposition. And Michael, who sent me a note, says, Steve, I'm curious to know who's going to pay that, because it'll get paid. But does the attorney pay it, or does his client pay it? And I don't know if the judge put that in the order or not. Quite often, the judge will simply just say, it's going to be paid by somebody on this side, and it better get paid. So we'll see what happens. But that might raise for you the obvious question, Steve, have you ever had a case where something happened and you discovered that your client's case was no good? And it's happened. It hasn't happened a lot. Most of my cases, being lemon law cases, are pretty easy to flesh out quite early. So someone comes to my office, they say, Steve, I got this brand new vehicle. It's been in the shop a bunch of times, and it's in there for this problem, that problem, and it can't be fixed. I say, okay, show me your purchase agreement, purchase documents to show when you bought it, what type of vehicle it is, and that you bought it brand new. Okay, that's easy, and you should have that. Show me the repair orders. People show me a bunch of repair orders. Brought it in for this problem, it's all described in the repair order. And they tried to fix it, didn't work. Boom. That's the outline of the case right there. Now, I've had defendants try to say, but Steve, after the last repair attempt, we fixed it. My client says it's not fixed. That's what a last chance repair is for. But that doesn't mean my client hasn't got a case. So a judge might say, why don't you let them fix it one last time? And if it works out, we try to do that. But I've had someone come into my office before that told me a story where the story was completely believable. And they had a bunch of evidence to back it up that they could show me. And I looked at it and I said, okay, I'll take this case. And I filed a lawsuit, and an attorney contacts me and says, hey, Steve, I see why you filed the case, but there's a problem with it. Let me explain it to you. And I've had an attorney actually show me evidence that somehow, despite what my client had, not only shows that they got a great defense to this, but that once you see all of this evidence in context, suddenly you go, oh, as unlikely as it is, that's actually what happened. And I can think of one or two, but I can't go into the facts of them here, but I've had one or two cases in my career that I can think of where I actually called up my client and I said, did you understand this, and this? And I've had a client go, no, I didn't realize that. And had the client come in and we go over everything. My client goes, you know something? Don't have a case. And you call up the other side and go, you know what? We'll dismiss our case. And I've done that before. And I've also had it, and this is a not as serious thing, but it is something you should be aware of. I routinely file 7 and 8 count complaints on lemon law claims. So complaints will say there's 7 or 8 counts here, one of which is the lemon law, a couple of which are breach of warranty, Magnus Moss Warning Act, so on and so forth. And I've had it happen before where somebody on the other side goes, hey, Steve, just to let you know, you don't have a very good case on this count or this count or this count. But the other 5 you do. The other 4 you do. And I'll say, yeah, I'll stipulate to dismiss these counts. I was waiting to see what played out as the litigation proceeded. And that's not uncommon either. But for an entire case to go away, that's a little unusual. Especially because here, the argument was that Arizona Beverages made a drink called an Arnold Palmer Light, which is a mixture of tea and lemonade. An Arnold Palmer Light. And there was a plaintiff who presumably said, I bought it because it was described as light. Turns out it's not light. Therefore, I've been ripped off. Lawsuit gets filed, and at his deposition, they asked the plaintiff, did you drink this? Yes. How many did you drink? Quite a few. When was the last time you had one? I still drink them. Drinking one right now. Just making that up. You didn't stop drinking them at any time because you felt you've been ripped off? No. It is extremely difficult to go into court and say, my client got ripped off when he bought this product, but he keeps buying it. Now, there could be an argument if there's a product that somebody needed and they couldn't get a replacement for it and they're being ripped off by, say, the price, okay? But here, it's a beverage that you drink just for refreshment. And so the guy's still drinking them. What's the argument now? You're being ripped off, but you know it, and you keep drinking them? And apparently, he testified and said, yeah, I like the drink. I just don't think it's light. But why are you drinking it again? Well, I like them, So there's a problem. So, yeah, not every lawsuit that gets filed automatically results in a windfall for the plaintiff's counsel. And in fact, this is a pretty bad result. So it kind of gives me the chills reading this headline, written by Steve Corus. Thank you, Michael, for sending, by the way. MadisonRecord.com. Arizona Beverages awarded $154,000 as a judge finds the attorney pursued a fraud claim for a plaintiff who loved the product and kept drinking it. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Everything is within walking distance, if you have the time.